welcome to Family Matters, the podcast where we dive deep in the world of divorce and family law. I'm your host, and today we are thrilled to bring you another episode from the legal practice Stearns-Montgomery Proctor, a family law firm founded in 1988. Stearns-Montgomery Proctor is dedicated to providing competent legal advice and advocacy in the complex realm of family law. Expertise spans various issues including divorce, child support and custody, alimony and spousal support, paternity and father's rights, and adoption. With over 3 decades of experience, the team has witnessed the evolution of family law and has developed a profound understanding of its intricacies. Join us on Family Matters as we explore the various aspects of divorce and family law, share valuable insights, and provide guidance to empower you through your legal journey. Today we will interview Ryan Proctor, one of the partners at Stearns-Montgomery Proctor, as we discuss income deviation and high-income child support payments. Before we start, here's a short introduction of Ryan and who he is. After working several years as an attorney, Ryan was drawn to Stearns-Montgomery because of its reputation for high ethical standards and exceptional levels of client contact. In 2010, Ryan became a partner and the firm's name changed to Stearns-Montgomery Proctor. When Ryan isn't practicing law, you will find him spending quality time with his family, often escaping the city to explore nature. Ryan, welcome to today's episode. We're going to be talking about support today and child support, and we're going to look at both sides of the spectrum in this conversation. So we're going to dive straight in with this one, Ryan, and I'm going to start with a question which I think a lot of people are facing, especially in today's economic climate. They are looking at a divorce, they are facing the fact that their lifestyle is going to change, and they are going to be having child support discussions, but there is just no money available for the child support. What happens in situations like that?
We've done another podcast about calculating child support, and that's going to be in more typical income situations. So check that out. This podcast is going to deal with more extreme situations where someone may be disabled or unemployed, or the income is just not there to be able to provide support. How is the law going to approach that? And we're also going to look at situations where we have extraordinary amounts of income and look at how the law approaches that as well. So when we look at a situation where someone simply doesn't have enough money to pay any child support, and this may be because of unemployment, disability, any other number of reasons, the law requires both parents to provide some level of financial support for their children. And so when we use our child support calculator and we put in the data for parent income, one parent may say, I have no income. And so what happens then? The formula would generate a child support obligation in that scenario of $0 for that parent. And that leaves the other parent with 100% of the financial costs associated with raising a child, which are significant. So there are very few situations in which a judge would allow someone to have a zero income. And that is generally going to be to a person that has a verifiable disability, a complete inability to work. Now, for other scenarios, the judge has the authority, and attorneys or parties may argue about something called the earning capacity of a party, or maybe someone is underemployed or unemployed, and it's possible to impute income to that person. And so for a person that maybe is just going through a rough patch, maybe they were earning $5,000 a month. For the time being, they're collecting $1,200 a month in unemployment. It may be that they could have a temporary modification of the support amounts, but on a permanent basis, I think that a court, and certainly the parent expecting the support, would look at an imputed income based on earning capacity. And for people that just don't have jobs or are unemployable for this reason or that, the court very often utilizes an imputed income based on the statutory minimum wage. The law will presume that most people are capable of obtaining minimum wage employment. And that's going to run somewhere in the neighborhood of $7.50 an hour, about $1,300 per month on an income level. And if we use that income as theoretical income for that unemployed or underemployed person, that's going to probably result in a monthly child support payment in the neighborhood of $175 for one child, a little bit closer to $250 a month for two kids. So if you are truly unemployed and the judge has told you you will be required to pay around $200 a month in child support, then you will be expected to come up with that money. And if you do have a disability situation, I think you would want to go through the disability process. If you qualify for Social Security disability or have Social Security income, some of those funds are allocated to a child, and that can actually replace or significantly reduce the amount of child support that you may have to pay out of pocket. So those are some options and theories to look at in situations where we don't have enough income. But what about situations where we have extraordinary amounts of income? And so we do run across that. There may be someone who is a celebrity or an athlete or a successful business person or just an astute investor. And so, again, we look at our child support formula and we put in incomes. And when we look at those incomes, the formula determines that at this income level, a family should be spending this amount of money on a child or two children or three children. So if we have a combined parental income of, let's say, $10,000, that formula dictates that the child should probably be costing them in the neighborhood of $1,500 to $2,000 per month. Now, if the combined income is maybe closer to $5,000, then that child support payment may be somewhere between $500 and $800 per month. But what if we have a situation where maybe one parent earns $5,000 a month, but the other parent is making $50,000 a month? So we get into a high income situation there. And for child support purposes, we start to look at the high income concept when the parents' combined income is at $30,000 or more. Okay, so we can run these different child support scenarios, but there comes a time, let's say dad has custody, he stays at home, is raising the kids, doing volunteer work and things like that, and mom is making $10,000 a month. Well, her contribution to the child support then might be in the neighborhood of $2,000. But what if she's now making $20,000 per month? Well, that may come up to $2,200. What if she's making $30,000 per month? Now we're at this high income threshold. Her support obligation under the formula is going to be right at about $3,000 per month. So you can see with the increase of income, the amount of monthly support increases. Now, let's say again, the dad has custody and he's at zero or very little. Instead of $30,000 a month, let's put mom in at $30 million per month. The formula is going to generate a monthly payment for mom of right around $3,000 per month. So this calculation they use, it reaches a plateau and then it stays there. But is that fair? Is that fair for the children involved? Is that fair for, in our scenario, dad? That mom is making $30 million a month and has to pay only $3,000 in child support? Well, probably not. And so we start to deal with the concept of what we call a high income deviation. Our child support laws and our child support calculator contemplate a number of different scenarios that allow for deviations from what the formula identifies as the presumptive amount of child support. And one of those is based on high income. Others could be based on one individual's living expenses. It could be based on certain special needs of the children, extraordinary educational costs, for example, private school, ongoing medical needs, physical therapy, and things of that nature. It may be that the parties are generally in agreement that the child will participate in some kind of private lessons that could be costly. So let's look at those scenarios. And all of those kinds of deviations that we've talked about are what we call discretionary. It's up to a judge whether or not those discretionary deviations will be applied. And so, in our scenario, the mom that's earning $30 million a month, she may want the judge to decline to use that discretion. But the father with the children there is absolutely going to want some discretion, and probably as much as the judge is willing to go. And not all cases are resolved by a judge. It may be that the parties just find a happy medium that they can both live with. For the paying parent, child support is always too much. And for the receiving parent, it's never enough. So it hurts everybody in different ways. But we do need to find a way that keeps the children financially supported. And for families that have higher income, those children are usually accustomed to different kinds of things that other children may not have access to. Uh, so when we look at those discretionary deviations, again, it's up to a judge to decide. And how high will that judge go based on that deviation? I think oftentimes one of the first components is demonstrating more precisely what that income is. A person may be engaged in a profession that is strictly a W-2 income, and that's it. But at those income levels, it's often much more complicated. There are usually contracts and agreements and money coming from a lot of different places, and money that's associated with different kinds of business enterprises, money that has different kinds of tax consequences and treatments. Sometimes there are sources of income that appear on taxes, but which aren't really income. The stock options available through work would be one of those examples. A receipt of a stock option is often considered a taxable event for the employee who receives it, and is taxed as income, but it's not actually money in that person's pocket until those options are vested and then exercised. So it's important when you're looking at income to identify what kind of income it is, how does it fit into the calculation, and is that the true income? Oftentimes when people are self-employed, the income that shows on paper may not be indicative of the actual spending power that that person has. And so we may need to look at not just tax returns and tax paperwork. We may need to look at some business records, and we may want to look at some bank and credit card statements as well, so that we can see what a person is spending compared to what they're making. On paper, someone may show that they are earning $2,500 a month, but that doesn't make sense if they're spending $15,000 a month on their normal living expenses. And someone may show that they have a monthly income of $30,000, but a lot of that may be income streams that are not actually considered revenue, like those stock options. It could be in other vehicles for investment purposes that look like income but isn't money. And so you need to really look at what these things are. Whether you're requesting or paying child support, you want to have a pretty true idea of what the true income numbers are, so that you can identify what your exposure is, or what kind of revenue you're going to have in the form of child support to help you meet your monthly expenses.
Sorry, can I just, so in our previous podcast, you mentioned and you gave the advice that the starting point for anyone going through the situation, and I think this would apply to high income and low income, would be to have that documentation ready, to have anything available that's needed in order to input that data into a child support calculation, so that you can get to that final number. And what I wanted to find out from that is, when it comes to these high income families, and you mentioned now an example of stock options or something like that, where it isn't an income directly to the person or the parents, until the point that that does become available, or when that does become available, is does that still factor into those decisions? So could you look at an agreement where if there were stock options and things like that, if those funds became available at some point, that would then factor into the child support agreement? Or does that, once it's eliminated, it's eliminated? It's not something that can be looked at.
I think each judge is going to look at certain components of income in slightly different ways. And a lot of it depends on what the nature of that particular income is going to be and whether that's considered an asset. For example, a retirement fund or home equity is considered an asset, but is having $1 million in a retirement account impact what your ability to pay child support is? Probably not, but maybe. And that $1 million that you have invested, if it generates $50,000 a year of dividends, well, those dividends are income for purposes of child support. Or let's look at a scenario where you're contributing $20,000 or $18,000 of your income each year to a retirement fund. Is that money's not available to you to pay child support, but the judge is probably going to consider that as income available to you that could be applied to your child support obligation. In the case of stock options specifically, I think a judge is going to look at that as a future asset and something to be divided, but it could be considered as income for child support. Judges have what we call broad discretion in determining what the facts are that they are going to use to fashion their decision. And when we look at appellate standards, somebody may not like what the trial court judge has done, and they may want somebody else to look at that number. The appellate standard looks typically in family law cases for an abuse of discretion. An abuse of discretion would really mean that's crazy. Nobody could have come to that conclusion based on these set of facts. And judges are also allowed to use any evidence to support the determination on this fact. What is the income? And so maybe somebody came in and said, yeah, that's income. And somebody else said, I don't know if that's income or not. The judge can say, listen, I heard testimony from this witness that said that was income. I'm applying it to the calculation for child support. And that may not be right, but it also may not be something you can succeed in changing on appeal or in requesting a future review.
So one of the questions that came to mind as you were talking was, and it was when you were working that formula out. So you get to earning $30,000 a month, and you're looking at a $3,000 a month amount being paid out. You look at $30 million, and you're still looking at $3,000, and that's obviously not fair. And that's when you start to work out what the correct amount is going to be. What I wanted to find out is, what if you've got a parent that says, but I don't necessarily want my child to be living this extravagant lifestyle that they've been living. I don't believe it's benefiting them. I don't believe it's serving them in any way. I want them to make their own way, in the world one day, and to be able to find the skills to make this type of money on their own and not rely on what I'm now handing out to them. How much of a say do they have in that? How much of a say would a parent have in a situation like that? So obviously they want to be fair, and they're not saying I'm not going to give anything, or that it's an unrealistic amount that they're going to give, but they're saying, well, actually $3,000 a month, my child can live quite comfortably on $3,000 a month support from me. And these are the reasons why I think that this should be set. Would a judge listen to a parent in a situation like that?
So I think that positions on that can go either way. And if you're going to go in and take one of those positions, again, because the law is not clear, it's up to the judge to decide, right? And it can be based on anything. So if you are interested in keeping the payment at the lower level, then I think you start to look at, and these are concepts that we actually use when we talk about determining spousal support. What is the need for support? In alimony, it's for a spouse compared to the other's ability to provide it. And so if I am going to be the custodial parent, I'm going to want to come into a courtroom with documentation of why I'm asking for $20,000 per month in child support, for example. What am I going to do with that? And some examples could be, private school tuition. Over at Woodward, it's $40,000 per year. And if you average that out, it's $3,500 a month. So that's going to that. We have traditionally sent our kids to this sleepaway camp, and that's going to cost $5,000 each for their summer. And the piano lessons for our daughter are this, and our son's involvement in Eagle Scouts is that. And, typically the children do A, B, C, D, E, F, and G. So you're going to want an outline. If you're going to be asking for that much money, explain why you need it and how you're going to use it. And another great explanation may be, it's also my intention to be able to put $2,000 per month into a college fund to start saving for what I expect will be the cost of college. No judge can order either parent to pay the cost of a child once that child is 18, or if they're still in high school, slightly longer. So a judge generally isn't going to have the authority to say, yeah, you're going to have to pay for college. That parent that's looking at trying to obtain support, they want to show why I need this amount of money. How am I going to spend it? And the parent that is looking at having to pay the high income kinds of child support is going to be looking at what is their ability to pay. So they may want to craft a very careful budget identifying what's going on with their money. And so saying, yes, I do have $30 million as gross income. But by the time the taxes are taken out of that, and the courts will always use gross income, net income is too easily manipulated with things like different kinds of investments and withholdings and a number of things. So they always use gross income to put that number into the worksheet, but you often have to make net income arguments. And so if I do have a $30,000 or $30 million per month party, they may be bringing in only in the neighborhood of $12 million a month after they have those tax obligations. And from that, they may well be responsible for the payment of, if the parties were divorced, they may be paying off lines of credit. They may be responsible to pay alimony to that former spouse. They may also be making contributions, whether voluntarily or by agreement, towards a college fund. And so identifying my $12 million, by the time we take out all of these things, and by the way, these are going to the kids and these are going to their mother, I really don't have that kind of money left. So, you want to address it from my ability to pay the amount they're asking doesn't exist. I would also want to approach that from, I may have the ability to pay $20,000 per month, but I don't think it's reasonable or I don't think it's necessary. Their proposal includes $1,000 a month for haircuts. That's not reasonable. So you want to start to chip away at some of those numbers. Historically, they've never done this $5,000 per summer camp. I don't know about having this request with that amount. But if it comes up, sure, I'll be happy to pay my share of it. But don't make me just pay for something that may never exist.
When it comes to, and I know, so you've got your child support that needs to be factored in, you've got alimony that needs to be factored in, and I know that these are separate entities that need to be dealt with on an individual, and in those situations, on an individual basis. When a judge is looking at the bigger picture, and I'm assuming that a judge would be looking at the bigger picture, so you've got one person who's got this high income amount, and as you rightly said, it's a certain amount is possibly going towards alimony, a certain amount is going in, and you start to chip away. When they are deciding on that child support amount, do they factor that into their decision? Do they factor in that, okay, well, this is the amount of alimony that this person is already contributing to this household. Therefore, the child support amount can be offset, or can we can factor that the child support would be this amount because this is the amount of alimony that is already being paid.
I think that the court would look at that. Let's look at maybe a more realistic example. Let's say there's an income for one parent at $50,000 per month. Okay, that's a healthy income. It's not 50 million, it's 50,000. But again, by the time you look at taxes, maybe other health insurance and other things that are paid, that number can very easily get down to, look, by the time I pay my bills, I've got $5,000 a month left. And the other parent is saying, I'm going to need $20,000 still. 20,000 of an $80,000 amount may not really exist. And so put it in that perspective, looking at the ability for that parent to provide that level of child support is going to have to be, I think, based on that alimony consideration. What is the need, and is it legitimate, and what's the ability to pay? So, and also, I think if you were the higher income parent, you may also want to be looking at ways to come up with a number that will resolve the case, as opposed to having it litigated. Litigation is done in a public forum. And through litigation, that other person can send off to request all of your bank statements and pay stubs and financial records of all kinds. And they scrutinize what you're spending money on. What kind of chances does that higher income person want to take with having that kind of scrutiny of their income and expenses? Maybe they have business partners and business records are being subpoenaed for production. The partners probably don't want that kind of information put out because one of them is having some kind of a lawsuit with a spouse or former spouse. So there are privacy considerations to look at as well, and trying to come to a number that may actually work to resolve this by agreement instead of forcing it into a courtroom. And so we may often see that result when we're looking at these high income amounts.
What are some of the more common challenges that you've encountered in high income divorce situations when these families come to you? What are some of the very real challenges that are presented that you have to navigate your way through? And how can parents or families prepare for those situations?
One difficulty that we encounter is that high income may be more of a shooting star than a comet. And so let's look at the situation where the parent does have a $50,000 per month income for that particular year, but the year before it was only 20,000. So there's been a substantial increase. Maybe that's related to a severance package, an extraordinary commission, just had the best year ever, got lucky. And so one parent may want to look at that and say, listen, they made $50,000 a month and I'm entitled to my high income deviation. They can afford it. But the parent with that $50,000 a month income may want to be looking at an approach that says, listen, yes, I did make that $50,000 this past year. But if you look at the year before, it was $30,000 a month. And the year before that, it was only 10. So as you can see, my income is all over the place. That's what we call variable income. And what we typically do with the variable income is try to come up with some kind of an average result. And that average might be taken over a period of 2 years. It may be taken over a period of 10 years. Depends on what is going to make the most sense for that circumstance. For a person that's at a high income level, it may be from a singular project, or it may be that they have historically earned at that level, but are looking at a retirement, a corporate restructure, taking some kind of a leave, or even a retirement, maybe. or looking to just change gears from the grind that it takes to generate that kind of income to maybe devoting more time to philanthropy or travel. And so there may be arguments to be made. Yes, it's been at this level, or I did have it at this level, but it's not going to be. And so, what is the judge going to do with that? I think in those situations, again, coming up with some kind of an average of what the income could be. And for the person that says, "Listen, I have enough money, I want to retire," or "I've received this money for working on this project, and now it's over," it's not going to be there anymore. A judge has got a tough decision to make. Do I place this person in the position as if they are earning that amount of money moving forward, at the risk of that person having to come back to court in 6 or 12 months to ask for an adjustment? Or do I give them a break at the risk of that person going out and having that same high powered earning capacity magically again at the expense of the child and the parent that may need that additional money? So judges have to make difficult decisions every day. They make some of the most difficult decisions and see some of the most terrible situations that you can imagine. So it's a difficult job for them to do. And at that point, really, it becomes about the presentation that you're making. And I think having an experienced attorney that is able to make that presentation, maybe anticipate the presentation that the other side will have and be able to counter that to some extent. And ultimately, I like to come to a judge with a reasonable explanation and a reasonable outcome. It's easy enough to walk in and say, "My client wants everything that's possible, give them nothing." But does that give the judge something to use in fashioning a decision? Not really. But if we come in with a solution that can work for my client and is actually doable and makes sense, I think I've given the judge an idea on how this case can be resolved by their decision. So that's where having a capable attorney is going to be important. And if you're the high income earning spouse, or if you're the spouse that's hoping and maybe needing to receive more than the presumptive or standard amount of support, having an attorney that can guide you through, these are the explanations we're going to make, these are the documents that we're going to need. And by the way, let's make sure we don't forget about that college fund that you want to include, or the fact that there has been discussed or there will be a need for these college prep courses. And let's make sure that we add those costs. And if maybe the money parent has purchased a vehicle for that child, well, we want to make sure that that parent with the money is going to pay for the maintenance and repairs and insurance that are associated with that vehicle. When we look at child support arrangements, whether by agreement or court order, it can be summed up that the custodial parent is responsible for all of the expenses of that child except what is specifically allocated to the other parent. So if you don't have that list of things that the other parent is responsible to pay for or help with paying for, you can ask them, but they don't have to give it to you. And so a capable attorney, a skilled attorney, is going to be able to identify what those things are and make sure they're accounted for, make sure that those kind of things don't slip through the cracks. And we also could look at certain kind of adjustments, maybe cost of living adjustments. Courts don't favor child support amounts that are subject to recalculation or reconfiguration or that are variable in any way, but there are creative ways to do that. And the law also allows us to do a few things nowadays that they didn't used to do. And one of those would be factoring in that there are 3 kids today. Next year, there will be 2. 3 years after that, there will only be 1 child. So let's build in those adjustments in child support now. And trying to find ways that reduce the potential for litigation in the future is, I think, the responsibility of an attorney in this case. Let's put this family on a path that doesn't have them needing to come back to us every so often. Let's find a sustainable solution that will work.
Ryan, do you have any additional advice, anything you'd like to share with families that are starting on this journey now, that are considering a divorce and need to look at how they're going to be moving forward?
If you are in that high income situation, I would assume you're in a position to get an attorney and do that. Of course, you can reach us through our website. You can call in. We have an immediate online chat, and we've got email addresses. Set up a consultation at least if you're in one of those lower income situations and you're not sure if you can afford an attorney. Get a consultation with someone like me at my firm or another firm. I often have people call and say, listen, I really can't afford an attorney. And what do I do? And I can send them to some resources that are available within their community that may provide some kind of assistance with an attorney for them, or be able to place them with an attorney at a significantly reduced price. So go out and get some information about your situation before you start to make decisions. Try and educate yourself as to what you're looking at and what the possible outcomes are so you can choose the best course of action for yourself. Another piece of advice, I do have people who will come in and they've had a change in income. They were divorced 5 years ago. Their child support was set at $3,000, but there were 3 children. Now there's only 2 children, and they want to look at a modification of their child support. But when we run our calculations, we see that the income levels have changed and they've gone up, and that the child support exposure for 2 kids might actually be more than what they were paying for 3 children. And filing that modification lawsuit, whether on their own or with the help of an attorney, is not the right move. They might end up paying more. So a consultation with an attorney that can get you pointed in the right direction, I think is something you should certainly do before considering any kind of legal action.
I think it's so important for people to remember that having an attorney on your side is that attorney fills so many roles. You know, they stand on your behalf, they guide you through the process, but they also ground you. And I think that that's such an important step, is that when you're coming into this process, you've got someone who can say, I understand that this is where your expectation is, but this is where reality is. Let's get there. And I think that that's so important to remember as well, is that when you're seeking advice and you're looking for somebody who can assist you through this process, they're going to be filling so many different shoes through the journey that you're walking. And to bear that in mind as well, is that that is so advantageous in the situation that you find yourself in.
I think it's important to be honest with people about the situation they're in. And I rarely have good news for anyone. We're dealing with families that are in a state of disarray. It's all damage control. And the news and opinions I have are not usually what people want to hear, but it is what they need to hear. Uh, and we do need to look at longer term consequences and put in cost benefit analyses. The emotion of a particular moment might indicate pursuing a certain course of action, but the long term consequences of that may not justify that kind of decision today.
Absolutely. Very, very true. Ryan, I want to thank you for your time today. It's been great chatting with you. If anybody would like to reach out, Ryan has given some ideas on how you can get in touch with them at Stearns, Montgomery and Proctor. Be sure to look out for our next episode. Have a good day.